If you've ever lived in a planned community, you definitely know that disputes with the Property Owners Association, or POA, can be, well, pretty common. But we're about to dive into a case that goes way beyond your typical disagreement. It all started with one homeowner's simple question and ended up uncovering a secret that had been buried in legal documents for decades. So this is the incredible claim at the very heart of our story. A homeowner argued that her entire property owners association had just ceased to legally exist after 50 years. I mean, could that really be true? Can an entire POA just run out of time? All right, let's set the scene. This whole thing played out in an administrative hearing. On one side, you've got the petitioner, a homeowner named Pamela McKinney, and on the other side, the respondent, the Valle Vista Property Owners Association. McKinney's argument was honestly stunningly simple. She claimed the association's original charter had a 50-year lifespan, and that timer ran out in May of 2022. But the board was still trying to enforce rules and collect fees from residents of a corporation that, in her view, was legally a ghost. You know, when Pamela McKinney first presented her evidence, it seemed like a total open and shut case. She had documents, she had emails, she had letters, and they were all from the association itself. It really looked like she had them cornered. So this was her smoking gun, the original 1972 Articles of Incorporation. Article 8 in that document clearly states the corporation would terminate after 25 years with the privilege of renewal. So McKinney argued this meant one 25-year term plus one 25-year renewal. You do the math, that's 50 years, and that's it. Next up, she presented an email sent from the POA's very own office, flat out telling residents that the association is expiring. I mean, it's pretty hard to argue with a direct admission like that, right? And the evidence just keeps piling up. This next email from the POA admitted that their big attempt to get homeowners to vote for a renewal, well, it failed because not enough people participated. So here's the magic number. The rules required a 2/3 majority vote. That's 66.67% of all property owners to approve changes. And in their own communications, the board basically said, yep, we did not meet the threshold. And for the final nail in the coffin, or so it seemed, McKinney presented this really dramatic letter from a board member. It's this desperate plea, warning homeowners that without that yes vote, the POA just couldn't continue. At this point in the hearing, her case looked absolutely airtight. But then, it was the POA's turn to respond. And their lawyer presented a counter-argument that completely flipped the entire script. He argued it was never about a failed vote because, get this, a vote was never even needed in the first place. So this is really the central conflict of the whole case. McKinney saw a dead corporation that failed to get the votes to save itself. But the POA claimed the community's rules were actually designed to just renew automatically every 25 years. But how could that possibly be with a 50-year corporate charter? This is where the hearing took a massive, dramatic turn. The POA's lawyer revealed a piece of evidence that changed absolutely everything, a document that directly contradicted the 1972 articles that McKinney had built her entire case on. See, the entire foundation of her argument was that 50-year limit from the original 1972 charter. What the POA's lawyer was about to reveal was a document that showed this limit hadn't actually been in effect for decades. And here is the twist. The POA produced articles of amendment filed with the state way back in 1994 and then again in 1999. Both of these documents officially changed that termination clause, Article 8. The corporation's lifespan was no longer 50 years, it was now legally perpetual. You can just imagine McKinney's stunned reaction in the hearing. She explained that for years she had repeatedly asked the board and the office for any and all amended articles, but was only ever given the original 1972 documents. She had built her entire case with the only information they gave her. Okay, so with this bombshell piece of evidence now on the table, the administrative law judge had to make a final call, sorting through decades of documents and a whole lot of confusion. The final verdict was clear. The judge dismissed the petition, ruling that the Valle Vista POA had not violated its governing documents. But the reasoning behind that decision is what's really important here. So here's how the judge broke it all down. First, she found that, yep, those articles had been legally amended to make the corporation perpetual. Second, she agreed that the community rules themselves, what some people call CCNRs, were renewed automatically without a vote. So third, you put it all together. Since the corporation never expired and the rules renewed on their own, the board didn't actually do anything wrong. So you're probably wondering, what about all those panicked emails from the board? Well, the judge concluded that the board had simply been acting on bad information. They genuinely but incorrectly thought a vote was needed, which explains why they sent all those confusing messages to the community. They were legally in the clear, but totally confused operationally. So that's the story of one homeowner's fight against her board. But this case offers some really powerful lessons for anyone who lives in a community governed by a POA. All right, here are the crucial takeaways. First, and this is a big one, always request all governing documents, and that includes any and all amendments. A document from decades ago can completely change the game. Second, remember that what a board says in an email might not always be the actual legal reality. And finally, you have to understand the difference between the Articles of Incorporation, which is about the corporation's existence, and the community rules, or CLRs, which govern daily life. They're two totally separate things.
Ultimately, this entire case really comes down to one question every homeowner should probably ask themselves. How well do you really know your community's rules? It's so easy to assume you know how things work, but the truth might just be buried in a document you've never even seen.